Hi, everyone. This is John again, and welcome to week 8. You are almost there. Almost, you can see the finish line, and we are just about to make it. So, congratulations on getting through this far, and we are definitely on the home stretch. Just another milestone project to submit, and that's it. So we are very close. And I congratulate you for that. So this week, I mean, there's no discussion question for week 8. I just want to, I guess, take a few minutes to just outline what I perceive as the main takeaways from this class, and hopefully they're the same takeaways for you, or maybe you have others, which is fine. I just as I've taught this class many times, have really thought through what I think are the valuable takeaways for students, both from my own perception and feedback that I've received, and just want to outline those for you. I know that there are many things in this class that you will not remember, and that's okay. But some skills that we've discussed, hopefully you will take with you, and not just in the healthcare space, but in other spaces as well. And I want to sort of highlight those. One thing we've discussed was, at least from a high level perspective, is this concept between, or this distinction, I should say, between ethical issues and legal issues. I think one big takeaway for me is that you can act perfectly ethical. And of course, we're talking about the healthcare space. You can act perfectly ethical. You can do everything as you think you should in providing and delivering healthcare and providing treatment or conducting a procedure, and still have some legal liability, right? So, where does legal liability come into play? Well, we've discussed this, that there are 4 elements. Um, of course, we're talking about medical negligence. There are other causes of action. There are, as you've read through your textbook, unintentional and intentional torts. Of course, I'm just talking about medical negligence right now, which is an unintentional tort. You can act perfectly ethical. You can do everything you can to make sure everything goes smoothly in delivering healthcare, but something may go wrong, right? And and you may or may not be liable from a legal standpoint for medical negligence. It really depends. It really depends on whether or not there's enough um, evidence to demonstrate those 4 elements that we've discussed. There are 4 elements to a medical negligence case. All 4 have to be demonstrated by a preponderance of the evidence in order for there to be any legal liability for medical negligence. And that's really important. And I've reiterated this many times throughout this class because it is important that, again, we're not talking about I forgot to feed the dog last night negligence. We're talking about negligence as a defined term in the legal sense. There are 4 elements to that, and if any one of those elements is missing, there is no negligence. There's no legal liability, at least for medical negligence. So, the first is the duty. When is that duty created? It's created upon the formation of the physician-patient relationship. Second is a breach of that duty, so a deviation from the standard of care. And you really have to know what the standard of care is, and we've discussed how that's established. We've discussed you've got the reasonable physician standard, you've got the customary standard, and depending on what jurisdiction you're in, depending on what state you're practicing in, that standard may be different. It could be different. States look at that a little bit differently. So you got to establish the standard of care and then determine whether or not the provider met that standard. And that's, of course, always hotly litigated in any medical negligence action. What is that standard? The third is causation. Did the act of the provider actually cause harm or damages to the patient. And there are two types of causation. There's direct causation, there's proximate causation. Direct causation, was there a direct causal relationship between the act and the damages or the harm? The proximate causation is, were there any intervening causes between the act and the harm that would have sort of taken away from the act of the provider and put that causation on something else? Were there any intervening causes? And then finally, damages or harm. Were there damages? Was there harm? What was the extent of that harm? How can we quantify it? So those four elements need to exist, or there is no legal liability. There is no medical negligence, as we in the legal industry define it. So we've talked about, and one of my main takeaways from this class is the concept of legal analysis and looking at things analytically and critically. It's one thing, if you may harken back to our week 4 discussion question on HIPAA and privacy. Well, it's really easy to sort of look at that scenario and say, oh yeah, she shouldn't have done that, or the physical therapist shouldn't have done that. That seems like a HIPAA breach. And so really one of the takeaways is to don't think about things intuitively, as weird as that may sound. Don't think about things intuitively. Think about things through this analytical lens, meaning you've got the issue given to you. What is the rule? So maybe it was a breach, maybe it wasn't a breach, but what is a breach? How do you define breach? And we've learned that actually under the HIPAA regulations, breach, the definition of breach is actually fairly complex. It requires you to analyze a handful of factors and consider some exceptions. And so only when you understand what a breach is, can you really understand and even begin to answer that question. So what is a breach? What is the rule? Apply facts to the rule and come out with your conclusion. That's the way to look at things analytically. And so hopefully that was a big takeaway for you in this class. So define terms. What is a breach? Look at the relevant facts. Look at the rule. Apply the facts to the rule and define terms. And that's really your IRAC method of legal analysis: the issue, rule, application of facts, and conclusion. We talked a bit about, although we didn't really have an assignment on this, we talked about the business and economics of healthcare, both the private payer bucket of insurance and the federal and state healthcare program bucket, like Medicare, Medicaid, TRICARE, Federal Employee Benefits Health Program, and things like that. And what federal and state laws are implicated by each one of those programs. And things like anti-kickback statute, Stark law, the beneficiary inducement law, things like that. We talk about HIPAA and privacy and security, medical records, this dichotomy of governance between federal privacy rules and regulations, particularly the HIPAA privacy and security rule, and how the state laws also govern the handling of medical records, like medical record retention laws, and other privacy and security laws that may exist and be enacted by the state. So, anyways, those are some things to consider. Again, I really, really hope that you found some value and received, felt like you received value out of some of the skills that we've discussed, some of the concepts that we've discussed, and hope you can take those with you in your practice and your future endeavors. Wish you all the very best of luck. If there's anything I can do for any of you, please feel free to reach out, and best wishes for your future endeavors and your future classes. Good luck to y'all. Take care.